You may be seated.
Okay, well, good afternoon by 1 minute. And this is the next case. It's Jameson versus Fort Myers, correct? Ready to go?
Yes, Your Honor. May it please the court, good morning. My name is Ryan Reese. I'm with the law firm of Moore, Bowman and Reese, and I represent the Cohen property owner, Jim Jameson, in this case. And I'd like to reserve 5 minutes of rebuttal time, please.
Can I ask you a preliminary question? This is a little bit confusing to me. So we have this opinion from 2000, March, on the same case. Tell me what's changed. You have the same parties, the same facts, the same land, the same, and this was a takings claim, correct?
That's correct. It's a
Okay.
takings and order here, Your Honor.
It gets reversed and remanded. ... Tell me, does that mean for trial de novo? Does it mean for further proceedings or something else? And why is this not law of the case? Say, hey, this should be trial de novo, just get it on, stop following these motions for summary judgment, claiming it's a different ground. Well, what's going on there?
Sure. So, Your Honor, the remand in 2020 was for a trial de novo on the merits of the takings claim. And
Did anyone file a rehearing to say, clean up the language, let me know exactly what you mean?
I think it was clear in the opinion because the court's footnote in that case said that we expressed no opinion on the merits of the case.
So the overall gist of the opinion, a fair reading, you're saying is trial de novo, but it doesn't explicitly state that.
It doesn't explicitly state it, Your Honor.
So I mean, were they in due bounds in filing for another summary judgment?
Well, both parties filed for summary judgment. The
Well,
plaintiff-
you're complaining yours wasn't granted. You
Correct.
want us to summary judgment yours in your favor, correct?
That's correct.
Okay.
As to counts 1 and 3, Your Honor. And let me just step back
Bert
to.
Harrison, the takings.
Correct,
Okay.
correct. The count 1 takings claim. The count 1 claim is a categorical takings claim under Lucas alleging the deprivation of all use. If this court were to find that it has been a deprivation of something less than all use, we wouldn't fall in line with Lucas's categorical rule.
That would be
And that's
the
when we-
43 lots, the 37 lots. Not 90-something% of the land can't be used. They offered in relation to the Bert Harris claims, the use of 3 lots. If you did this and if you did that, and if the council approved it, which there's no reason to doubt that they wouldn't approve it though.
I think there's significant reason to doubt that they wouldn't approve it. And I think Judge Morris's comment.
Is that
first
in the
appeal-
record or outside the record?
Well, it's Judge Morris asked me the question, or asked opposing counsel the question. Well, it seems like you've got a hostile counsel. You know, it seems like this council doesn't want this property developed as anything other than a wetland. And I cited that parenthetical in the brief. I think it's very clear. I mean, we made 4 development applications to develop this property, and all 4 of those applications were denied. No use of the property whatsoever. So.
Well, the judge went through the whole checklist of why he granted summary judgment for them. Right? It was wetlands when they bought it, they were on notice, it wasn't gonna be developed. It's 20 acres for one house, you're well under that, et cetera, et cetera, et cetera.
Yes, and I want to step back to the very first point you asked, Judge Penalty. The first appeal was about affirmative defenses. It was about the merits of the town's ripeness and purchaser with notice affirmative defenses to our client. It's never been disputed in this case that there's no use of this property under existing regulations. The wetlands land use classification, the environmentally critical zoning classification, all of the town's decisions, and all of the opposing counsel's admissions in the record from this case from 2017 until the appeal in 2020 were that this property absolutely unequivocally cannot be developed. Okay, so we went to this court in 2019 to determine whether we had a ripe claim and whether we were barred under purchaser with notice principles. And the 2019 court panel of this court rejected both of those defenses as a matter of law, remanded the case back, expressed the footnote that they were making no determination on the merits of the claim, the takings claim or the Bert Harris claim, and sent it back for a trial on the merits. Well, we didn't need to have a trial. We immediately removed for summary judgment because the town's regulations are categorically dispositive. You cannot develop this property. It was only after this court's remand in 2020 that the town altered its litigation theory to say, oh, well, Mr. Jameson actually does have use of his property because we tendered him a settlement offer on the count 3 Burt Harris claim that says you can use 3 lots.
So you're saying the Burt Harris claim was kind of strategic? It was done to confirm that it couldn't be used? You thought they would say it can't be used, but said they make you what you consider to be an illusory offer of settlement.
The Burt Harris, this is a categorical takings case. I mean, this is a Lucas case. You look at the regulations in effect, still today, Mr. Jameson cannot use his private property for any economic purpose. We pled a partial takings case claim in count 2. In the instance, just to protect ourselves, the trial court of this court found that there was some use of the property. We still contend that there is none. So that claim was pled in the alternative.
Well, you have the Swiftmud said 1.59 acres, I believe, is uplands, which means it is usable. It's not all wetlands under their definition.
Swiftmud is the entity responsible for managing wetlands in this state. We had, if your Honor is correct, we had a 2010 delineation that's been renewed every 5 years since. It said 40% of this property is uplands and surface waters, which can be developed. And we contend that if we go to the state, the wetlands here are man-made. We're exempt under the Florida Administrative Code rule that we cited in our brief. We're exempt from wetland permitting requirements. And that's not to mention that the state of Florida allows mitigation in wetlands. You can build in wetlands if you mitigate it.
Well,
The town offers.
There's buildings all around you. Are they in wetlands also?
That's a question for the town, Your Honor. I mean, that's what we've alleged. How can we treat this property owner differently? I mean, you look at the aerial, the whole beach is built out. We're just the last bastion of undeveloped property. And we're required to bear the disproportionate burden of the public good of protecting the environment.
You can do dockage there, can't you? Boardwalk. You can build people a dock and charge them a docking fee, and you can do boardwalks. Is this even does the Hayden have waterfront? I think they said that in their brief, that there is use of this property.
Not economic use, Your Honor. And the trial court did try and the trial court did infer that there was use of this property. The Lost Tree case that we cited in our brief, it can't be mere token use. It can't be passive recreation type use. The fundamental use of land, and this is in the, it's either the Ford case or the Corn case, and it's cited in Lucas. The fundamental use of land is for a residence, a single family home. That's why we have land. And so it has to be economic use. That's correct. The Lost Tree case that we've cited says just that. You
I'm
can't
going to
give.
reserve you 5 minutes for rebuttal.
Yes.
You want 5 minutes, okay.
So this is, and I want to say this up front, this is an incredibly simple regulatory takings case that has become incredibly convoluted by the trial court's rulings. This court needs only to ask one question to resolve this entire case. What use does Mr. Jameson have as his property under the town's existing regulations? The answer to that is unequivocally no use at all. Undisputed facts, the town does not dispute it. That is consistent with their litigation position all the way from the filing of this complaint in 2017 to 2020 when this case got remanded. Mr. Jameson has no development rights on the property. He can't use the land for any economic purpose. That puts us on all fours with Lucas.
What difference does it matter when the judge does this really detailed order denying your motion for summary judgment and granting the defendant's motion for summary judgment? What difference does it make when he cites on February 10th, 2009, the plaintiff obtained an undivided interest in the property? I guess he bought out his partner.
That's correct, Your Honor.
Who cares? Tell me how that's relevant.
That has no legal significance whatsoever. Under the Palazzolo case, United States Supreme Court 2001, I believe, it doesn't matter if you have notice of regulation. This issue formed the basis of the first appeal. It doesn't matter if you have notice of adverse regulations. In fact, this panel in 2019 put into the Jameson 1 opinion that Jameson bought the full property rights when he purchased the property, including the right to challenge the existing wetlands designation. So I would contend no legal significance whatsoever that he obtained a 50% interest in 2009.
Did the burden of proof shift to the plaintiff at any point in this case? The judge said the burden shifted to the plaintiff.
The
And
plaintiff,
ends the sentence there. In other words, you didn't carry the burden when it shifted to you. And I assume that's the implication.
the plaintiff has had the burden of proof on these claims, and we filed a mountain of evidence at the summary judgment stage. The plat, the minimum use determination, uncontested affidavits. I went out and got the town's former planners to file affidavits saying that development of this property would be reasonable, but for the town's wetlands regulation. That's the town's own guys.
Well, I think the judge is saying you didn't prove you had a vested right.
So that's with respect to the count 3 Burke Harris claim. And I'll be frank with the court, I don't think you need to get to count 3. I don't think you need to get to count 2. I think this case can be resolved on count 1. And the question is, look at what are the regulations in effect allow this owner to do? And the answer in the admissions is categorically no use at all. And that's where the town's argued that, well, we tendered you the settlement offer, allowing 3 lots as part of the Burke Harris claim. And that argument was purely born out of necessity. They had to find something to demonstrate that my client had a use of his property in order to avoid application of Lucas's categorical rule. And so they pointed to a settlement offer. And the trial court agreed and became the first court in this country to use a settlement offer as a measure of use in a regulatory takings claim. So
Is it a real settlement offer?
Well,
When it's
no,
conditional?
and those are all of our secondary arguments, Your Honor. So let me clarify and back up. This court can resolve the issue of the settlement offer merely by looking at regulatory takings principles. Okay? We've cited a host of a dozen or so of the major United States Supreme Court regulatory takings cases, 3 or 4 of the Florida Supreme Court regulatory takings cases. There is not a court in this country that has ever evaluated a regulatory takings case by looking at a settlement offer as a measure of that owner, the property owner's land use. Not a case. Town hasn't cited one, lower court didn't identify one. I've read hundreds, it doesn't exist. Okay, so just on that fact
This is not
alone,
just a party, this is a government entity saying, we're gonna change our decision. It's not just a settlement offer from a party.
it may be a government entity, Your Honor, but it doesn't change the outcome. It's still a settlement offer, and the town's admitted it's a
Well,
settlement.
they're required to make one under Burt Harris.
They are required to make one, yes, that's correct. But it's a separate claim, and if you look at the Burke Harris Act paragraphs, subparagraphs 1 and subparagraphs 9 of the Burke Harris Act say specifically that the Burke Harris Act is separate and distinct from the law of takings, and that the act is not to be construed under takings principles in accordance with the law of takings. So I direct the panel to that statute, paragraphs 1 and paragraphs 9.
So what's the relief you see? You want a summary judgment granted in your favor, you want theirs reversed. Then what do you want? You get a summary judgment, what's the next step?
So the summary
Evaluation,
that's correct, Your Honor. So it would be a
they
summary
keep the land,
judgment.
they can do whatever they want with it. They have to buy the land from you essentially. Right now, you're paying taxes on land, that's a wetland you can't develop, right?
That's correct. That's correct. So the summary judgment would be as to, these proceedings are bifurcated, takings proceedings and Burke Harris proceedings. And the reversal and a grant of summary judgment for the plaintiff on liability would be as to liability, a finding of a taking. What was taken, when was it taken?
What if the settlement offer was, you know what, we changed our mind, we're just gonna, this is not a wetland anymore. You can build an amusement park here.
That's what happened in Lucas, Your Honor. I did a little digging here a couple days ago, and actually Lucas was a categorical 100% takings case. And the Coastal Commission went back and they changed the regulations after the United States Supreme Court had.
So you're just saying, well, I could have had an amusement park for all these years and charged, $5 a head.
What it
So you owe
does,
me for that? Is that what you're saying?
what it does is it cuts short the taking. Okay, so what if they were to change their regulations and say you can develop the property now, there's still a temporary taking. And that's why I say that in my brief, that subsequent remedial actions of government after the date that the property is appropriated, which here is June 6, 2015, it's a date our variance application was denied. You have to apply for a variance to ripen a claim under Florida law. They denied our variance. That's the right, that's the date that our claim vested, that's the date we could go to the courthouse doors.
Down to 5 minutes, by the way.
Thank you, Your Honor, and I'll just briefly wrap up. Subsequent remedial action by government in the form of invalidation of the ordinance or a change in the ordinance or some type of land use concession or a settlement offer only cut short a permanent taking to a temporary taking. You still get compensation for the time period of which all use would be denied. So I'll reserve my remaining time.
Actually, I'm gonna save you 5 minutes.
Thank you, Jim.
Thank you. All right, I believe. You got 20?
Thank you. Good afternoon, Your Honors. Hudson Beal on behalf of the town of Fort Myers Beach. And I'm going to focus my argument today on the Lucas claim, count 1, because that's what he's focused on. To understand what the trial court did on summary judgment for that claim here, you have to go back and understand what happened at the first Jameson appeal. What the town argued below and what they prevailed as all 3 counts in Jameson 1 was that the claims were not ripe, which applies to all 3 claims.
This is going back to the first
I'm
appeal.
going back to the first appeal because you have to understand what happened
I
there,
got you.
what was
I
decided.
appreciate it.
What ripeness means is, you know, before a landowner can file for a taking, the landowner has to use the reasonable application process at the municipality to determine what the permissible scope of development is, what they're going to let you do before it files suit. Why is that important? Why is ripeness
Well,
important?
that you've lost that issue though.
I understand
Why are
that.
you telling us all this?
Because that is what it informs the court what the analysis is when it went back down, what the analysis is on count 1. Because what ripeness means then is why you need a right decision is because it says what the scope of
So
permissible.
you're saying reverse and remand is not for trial de novo, it's for another summary judgment.
Well, they made, yes, it's what could be for trial, but it was not there was law in the case that was decided in Jameson 1. And it's because of what was decided, because the ripeness issue was decided. This court in Jameson 1 said the claim was ripe, and it went through the process of all what was done to ripen the claim.
What's left to be decided? Once they say the claim is right, doesn't that mean
So what it means
filing a
is,
lawsuit?
then you go back down and you look at that scope of permissible development, which this court said it is 3 of 40 lots. And then the trial court is then tasked with determining whether that 3 of 40 lot offer is either a taking under Lucas, a taking under Penn Central, or a Burt Harris claim. That's what Lucas 1 says. I mean, it concludes, and finally, when he filed notice of a Burt Harris claim in 216, the town offered to settle the claim by removing the wetlands designation from 3 lots only, provided they give up the development rights to the remaining 37 lots. Thus, it was reasonably certain that the town would permit Jameson to develop 93% of its property based on the wetlands designation. That's the scope of permissible development that this court said the town, that was the decision, that was the final decision that the town said. We had argued below that the settlement offer was just an argument. We said it wasn't right, he needed to file an application. We pointed to the settlement offer as evidence to counter a futility argument. We said, look, this shows that the town was willing to let some development happen, he's just got to do the right application. They argued, no, you can't look at that, it's a settlement offer. We go up on appeal, that issue, whether it's admissible or relevant, was briefed. I've cited to where in those other papers it was briefed. This court kind of disagreed. It said, no, Mr. Jameson, it is relevant and admissible. If you look at footnote 3, it says it's relevant. But then it said, town, we disagree with you. It's relevant to show that the claim is in fact right. There is a final decision. This is the final decision, the 3 of 40 lots offer. So then you go back down and you decide whether that scope of this development constitutes a Lucas taking, a Penn Central taking, or a Burt Harris claim. Under Lucas, that's not a taking. I mean, he just basically admitted that it's got to be no development. 3 of 40 is not no development, so it's not a Lucas style taking. That's what the court ruled below, given that this appellate court has said the final decision, that the scope of this development is 3 of 40. That's not a Lucas style claim because you're allowing some development of the property. I mean, they say that one house is I think the Palazzolo case was 1 on 18 acres. This is 3 on 7 acres. So that's not a Lucas style taking. Now, with respect to whether it's a illusory offer or not an appropriate offer, first of all, that issue is law of the case. I mean, this court, we briefed all those issues, many of the same arguments were presented. This court said, no, it's relevant, it's
No,
admissible.
I guess the question was more like, is an offer if it's contingent ultimately upon town council approval?
Well, So first,
So it's not an offer that came from the town. Seems to me they should have made a formal offer, got the town to approval, give them a letter saying, we've approved this in response to the Bert Harris claim.
what the Burt Harris Act says we're supposed to do, which is exactly what we did. And it's in paragraph 4C, and it says during the notice period, the governmental entity shall make a written offer to effectuate, meaning,
But can that offer under a Burt Harris claim be used to defeat the Lucas claim?
I think it can in this case because of what happened in Jameson 1. This court said, we're gonna look at this
That's if
offer.
we construe it the way that you say.
I'm sorry?
That's if we construe it the way that you're saying.
Well,
I mean,
here-
there's
Sure.
another argument, right?
The issue would be though that, let's go with his argument and say, you can't now look at this when we go back down. So this court said the claim is ripe because the scope of development is known and it's this 3 or 40 offer. So the claim is ripe because of that.
Because they followed the process.
But then what would happen when we go back down below? Okay, well, it's ripe because of this.
So that would mean anybody could defeat a claim by simply making a settlement offer.
Well, I think, Judge, in this case, they looked at all we done, what we had said repeatedly was, our argument of ripeness was, you need to apply for something less. What you need to do is focus on the uplands area and apply for an amendment to the comp plan. They didn't do that for their reasons, and we pointed to that letter as an offer, as evidence that we would have potentially approved that. This court looked at that and said, no, well, this shows the scope of permissible development. So if we're gonna look at that on appeal and say, this is what the final decision is, but then when you go back down for the taking analysis and ignore that, it turns ripeness on its head, because ripeness is about what's the final decision, have you gotten a final decision? Here this court said, yes, you got it by looking at this Burt Harris letter, that's the final decision. So then you go back down and you look at that final decision and see whether it's a taking. If we're gonna ignore that, it seems odd that you would say that the final decision is 3 or 40 for purposes of ripeness, but then for taking, we're gonna look at something different. 'Cause that's what,
Yeah, I guess if you're looking at footnote 2, it says the town's offer to allow development of 3 lots is relevant. And to whether the town's position was known to a reasonable degree of certainty. And I know what you're saying, but I'm not so sure that you can just simply make a settlement offer to defeat another claim.
well,
When that settlement offer was required in the proceeding for a Burt Harris claim.
but the whole purpose of this, the provision in Burt Harris is, you can offer to allow them to develop the property, it's a pre-suit notice requirement.
But the 2 claims are separate, correct? The Lucas claim and the Burt Harris claim?
They are separate claims, but this court looked at, when it was determining whether the taking claims were all right, it looked at the Burt Harris letter to show as evidence that it was in fact right. And it does make some sense, because that provision in Burt Harris is a pre-suit notice. And the idea is you get notice of the claim, and then the municipality or the county has an opportunity to respond and potentially resolve it by saying, here's what we're gonna let you do on the property. Sometimes they say, no, we're not gonna change what we have, we're gonna stand pat and you can get what you get. Here, what they did is they offered to change the comp plan for 3 of the lots. It says we're allowed to do that. 1 and 2 talk about 2 is increases or modifications in the density, intensity, or use of areas developed. So had he accepted that, I mean, that's what he would have gotten.
No. You're missing a step. The offer had to be approved.
True, but
So, I mean,
but that is how municipalities and
and I understand that's how they work, but they're not always approved. I mean, that's not like 100%.
I would understand that, but in terms of, the act does not say, and it would be kind of contrary to how municipal law works, that we have to go and get an approval to do that. We simply have to offer.
No, not for the Burt Harris Act. I'm just saying for the Lucas claim.
Well,
Isn't that something we should be looking at? That's just simply an offer.
but my question, the counter question is then what was decided in Jameson 1 in terms of ripeness?
That they can go forward with their claim
It's because there's a final decision. And what
because
is
they
that?
went through the process.
And what is the final decision? Thus, it is reasonably certain that the town will not permit Jameson to develop 93% of his property based on its wetland designation. And then in footnote 3, it continues on and says, however, we make no comment on whether a taking occurred where the town offers Jameson the opportunity to develop 3 or 40 lots. That's what this court said the final decision is. So that's what is, for purposes of rightness, that's a final decision. So then what the Pompano Beach versus Yardarm case, the fourth which I cited, says, the purpose of rightness is so that you know how far the regulation goes, you know the scope of personal development, so you can decide whether there's been a taking. It just doesn't make sense for you to say it's right because of that 3 or 40 lots offer, and then below, but whoa, when we analyze a taking, we're not gonna look at what made a right decision, we're gonna go back to some prior point in time.
You're saying that it was known, it's known. It can be factored into both claims. But what about the argument that even if going forward, just presuming that the offer can be factored into the analysis of the Lucas claim, and going forward, there is no longer a Lucas taking. What about what opposing counsel said that there was a temporary?
Well, that was never framed in the complaint. There's never an allegation that there was a temporary taking. That wasn't teed up. That argument wasn't presented below. The first time he ever makes an argument that there's been a temporary taking was in his briefs. And it's simply not appropriate for you to raise a new claim, a temporary regulatory taking claim in response in a brief. And that's not appropriate to do that. If that's what they wanted to then state, they should ask to amend it below after that ruling on the Lucas style claim and said, no, we're going to start a temporary taking. I dispute that he says the variance denial, it wasn't a denial of fact. What we said is we can't process this variance application because of what it's asking to vary. We can't grant that kind of variance. I don't believe that's when the taking occurred. That's just not the final decision. The final decision doesn't come till later. So that's how the analysis went. The one argument he did raise below, which I'll just touch on briefly, is the Jurock argument that somehow that 3 or 40 lots offer were converted into 37 takings of each individual lot. And that's just a misapplication of how the Jurock opinion works. What Jurock said was there is a rebuttable presumption that platted, vacant, urban lots are separate for purposes of a taking analysis. But how that gets applied, and we explain in our papers, is in the Jurock case, there was they owned 3 parcels. There were platted, vacant, and contiguous. There was a FDOT road project that denied access to lot 1. So you couldn't get to lot 1 from the roadway. That property owner filed suits and claimed a taking of lot 1. DOT responded to that and defended it by saying, whoa, you have to look at the parcel as a whole, all 3 lots, because they're owned by the same person, they're contiguous for purposes of the taking analysis, and there is access from lot 1 through lots 3 and 2, so there's been no denial of access. The Supreme Court then in Jurock goes through the analysis of, in that situation, what you do, and you look at things to determine whether that parcel should be considered, those parcels as 3 lots separate for purpose of taking or together. And it looks at, there's several factors that it looks at, but it says when you're dealing with vacant city lots, there's a rebuttable presumption that they're separate for purposes of taking claim. But it's rebuttable, so you get an opportunity to defend that. Well, the problem here was he never raised that in the complaint. They didn't say that we're serving 40 individual taking claims based on 40 separate lots. They defined the parcel in the complaint as the property, 2 parcels with 2 separate deeds, 7 acres, and they're platted as 40 lots. In discovery then, because you need to define the parcel purpose of taking, we asked the specific question, what has been taken? Response, the property, and it defines it that way. It's always the property. It's not the properties. 40 separate lots. If they wanted to do that, I guess after the court ruled and granted summary judgment to us on Lucas, they could have amended the complaint or asked to amend, and we would have seen whether it was okay and said, okay, we want to state an individual claim that meets 30 on the rest of the 37 lots. We would have defended that and gone through the proper analysis of Jurock of whether it should be treated as one. But that's not what happened here because that was never the claim. And I'm not sure how much time I have left.
But in 6 minutes.
Okay. Thank you, Your Honor.
Why don't you talk about the economic benefit or the objectively reasonable development when the land was acquired by this plaintiff? Was there
So,
an expectation that it would be developed if it was designated wetlands and a
Well,
20-acre lot requirement
I
per
mean,
house?
no, there wasn't. When he purchased the property in 2002 initially, it was designated as wetlands on the town's comprehensive plan, which said that in order to develop one dwelling unit, you need to have 20 acres because it's a 7-acre parcel. It was not suitable for development.
Is the unless there's a variance given?
Well, What you would have to do, and what the town told him to do, was he would have to apply to change the comp plan, wetlands designation for some of the
A
properties.
small comp amendment or something.
Exactly, because again, as you pointed out, the South Florida Water Management District looked at this property and said that there is in fact 61% wetlands, 12% surface waters, which I don't agree you can develop those, and then the rest is 27% uplands. The town's position was kind of always focused on the uplands, develop that area because they're in fact uplands. And again, I went through the history a little bit of what happened there, but that's what the town's offer was, that they picked the 3 lots that were most upland and said, we'll let you develop those 3 lots because they're the most upland. But when he purchased it, it was not subject to development, it was consistent all the way through, and that's what really presents a problem in terms of the Burt Harris claim. Because the first step in the Burt Harris claim is establishing either an existing use or a vested right. That's a trial court's first role, and that's in the statute if you look at subparagraph 6. It says what the circuit court's supposed to do. Number 1, determine whether there's an existing use or a vested right to a specific use, and if so, then whether there's been an inordinate burden considering the settlement offer and the statement of allowable uses. So the first step, and what the court found here in the Burt Harris claim, is there was no existing use. The argument that they made below was that you're traveling under, and the nice thing about the Harris Act is that it defines the key terms and it tells the court what they're supposed to do. And the plaintiff here said, well, we're going to proceed under the second part of the existing use definition, which talks about such reasonably foreseeable non-speculative land uses which are suitable for the subject, real property, compatible and adjacent land uses, and which have created an existing fair market value in the property greater than the fair market value of the actual present use or activity of the real property. What the trial court found there was he couldn't satisfy that because of the comp plan. Because the comp plan is what controls development for any government that has one. You cannot issue development orders under state law that are contrary to the comp plan. So when you have a use that's not permitted under there, that's not an existing use. And that's what the Halls River development case says of Citrus County, and the Ocean Concrete case, which is the 4th DCA case. Ocean Concrete explains what that phrase means. It talks about it talks about land uses, future potential land uses, and they can't be speculative or hypothetical. And what Halls River tells us is if it's barred by the comp plan, it's by definition hypothetical or speculative. It doesn't establish an existing use under Burt Harris, and that's what the trial court found. And so for those reasons, if there are no further questions, we ask that you affirm the trial court rulings.
All right, perfect time, thank you. All right. You've
Please,
got
Court.
5 minutes.
So as you can see, conflating Burt Harris with constitutional takings claims and using a settlement offer to be able to, as evidence of an allowable use and Lucas and the constitutional takings claims, gets us really in the weeds in this case. I want to start with Judge Smith's question first. And Judge, you identified it exactly correct. If settlement offers were part of the Burt Harris calculus, no one could ever prevail. Okay, and I cite an example of this in my brief. Let's say I own 100 acres in Hillsborough County. Hillsborough County Environmental Services comes in and says, you got a ball beam on the property. Can't move any dirt, can't develop it due to the distancing requirements. Okay, it's protected habitat. We litigate the case as a Lucas claim. Much like this case, we litigate for 5, 6, 7 years. On the eve of the liability trial, Hillsborough County tenders me a settlement offer. It says, we'll give you 1 unit, we'll let you build 1 home on your 100-acre property. That right then and there defeats our Lucas claim. It is a categorical 100% no use rule. So if settlement offers were part of the equation, no landowner could ever prevail under Lucas for fear of the government entity always tendering settlement offers to avoid an application of the 100% rule. And think too, what if we hadn't brought up our Harris claim? And I thought about dropping the claim, to be candid, just because of this issue. What if we hadn't brought it? How would Jameson's Lucas claim have been measured? It would have been measured based on the regulations it issued. There never would have been a settlement offer because we wouldn't have brought that count of the complaint. And
But
so
is it based on the regulations or is it based on the decision under those regulations?
Fair point, and you're correct, Your Honor. It is based on an application of the regulations, but the application of the regulations is through the final decision requirements set forth in Palazzolo. To obtain a final decision, Palazzolo is clear, you have to make a written request for development and variance. We applied for a variance in 2015. It was denied. That was our final decision. Not a takings case in this country that has looked and said you have use based on settlement offer.
What about the uniqueness of this case, as argued by opposing counsel with regard to the prior appeal? If they resolve the issue of ripeness based on the offer from which this court, just don't want to speak for my colleagues, right? But this court inferred to me it is clear that the permissible uses of the land were known and that any further application to the town to change the wetlands designation would be futile. What about the argument that that means that it could be used for both cases?
For the merits determination of the ripeness is what I expected. I understand what you're saying.
I mean, okay, that's why it was included, but I mean,
Well,
it's the lay of the, no pun intended, it's the lay of the land.
there
We're
are,
arguing both claims after remand.
their law of the case argument is born out of necessity because they have no defense to any of our arguments regarding the invalidity of the settlement offer. So they had to say, oh, that this was already decided as law of the case in Jameson 1. The very first paragraph in Jameson 1 says this case is about ripeness and notice defenses. And as the court goes through its analysis, at the end of the second part of the opinion, it says, you know, Jameson did this in 2010, did this in 2012, did this in 2014, did this in 2015. Oh, and the town tendered him an offer to develop 3 lots. It was clear when Jameson filed his complaint that the permissible uses of the property were known to a reasonable degree of certainty. That reasonable degree of certainty language relates exclusively to ripeness. The court didn't need to, in the 2019 appeal, say anything about the settlement offer. We were right based on the 4 applications we'd submitted. And it's just a conclusory statement. The very first, I think, sentence in that paragraph says, it was clear that Jameson's uses were known to a reasonable degree of certainty when he filed his complaint, period. We were right. That's all that case was about. It was not a merits determination.
Does the ripeness argument relate at all to the economic expectation that the property would be developed when it was purchased if it was designated wetlands and you can't build on it? How help me through that
Sure.
inconsistency?
And I want to be clear because this is where the 2 claims differ very, very differently. In a Lucas claim, reasonable expectations are not a factor of the calculus. The economic impact alone is the dispositive factor. You don't look at the claimant's reasonable investment-backed expectations. That's the Palmer Giles case. I think it's in my brief. If not, I'll file a supplemental authority. But it says you do not, when it's a categorical taking, look at the landowner's reasonable expectations. Contrast that with Bert Harris, and you do look at reasonable expectations. But the town and the trial court's order say you didn't have reasonable expectations because of the wetlands designation. Well, that's why we challenged the wetland designation. That's the very regulation we challenged. So you can't use, and the trial, I put it in my brief, the trial court's logic follows as this. Jameson cannot prevail on his Bert Harris claim in demonstrating that an inordinate burden has occurred to the property because the wetlands designation he challenged precludes any expectation of use of the property. That's circular reasoning. And again, I mean, it's the very regulation we challenged in this case. You can't use that regulation that we challenge as evidence that we have no expectation. All the evidence below, the affidavits from the town's planners, the plat, our minimum use determination, I mean, that was a town council determination in 2014 of minimum economic use. Every platted lot has a right to is entitled, the town uses that word entitled in its codes, is entitled to a minimum residential use on each platted lot. I mean, that right there
You got
is
about 20 seconds.
that right there is our existing use. So as it relates to Lucas, no consideration of reasonable expectations, Joe. We would ask that the court reverse and remand this decision, reverse on all claims and remand this case with directions to the lower court to enter judgment as a matter of law in Jameson's favor on count one. And to Your Honor's question at the very beginning of my presentation, that would be a judgment of liability under Lucas. And then, of course, we would have another proceeding as to compensation.
All right, thank you, gentlemen. Well done, well argued.
Thank you.
We'll move on to the last case on the docket, which is Catherine Holton versus the state of Frank Holton Senior.